It is one of the symbolic issues that demonstrated grand level corruption, and we think a thorough investigation must be brought on the table.
Now we have an opportunity as a country to know exactly what happened, and also another opportunity to ensure that those who looted state resources at the time, who channeled funds that were supposed to use to acquire arms for the country, are brought to book.
Thami, will we ever get an opportunity to find out the full extent of this process?
I think we should. There's enough evidence for the NPA. There's enough evidence for the Hawks to actually go ahead and prosecute. I mean, this is public knowledge. This is information that sits with the NPA, that sits with the Hawks. And the instruction perhaps from the commission was not to necessarily prosecute people. And I think now that the court judgment has been handed down, I think it's time to revisit some of the evidence that is sitting with the NPA and the Hawks and the SIU and everybody else. And I think it's time that we prosecute somebody. It would be a tragedy if nobody gets held accountable for what transpired with the whole Amstel matter.
But this brings into question that conversation that's taking place right now about commissions and their efficacy, and whether they're really the right way to go in trying to uncover the truth about certain situations in the country. We look at the State Commission right now, the Commission into State Capture, where a very major person who has been mentioned by quite a sizable number of people testifying has suddenly passed away today. And you could link the same to the Seriti Commission, where Mr. Joe Modise passed away before he could uncover or tell the public what really happened. Is that problematic?
I think we have a bit of a challenge with regards to how the commissions of inquiry get conducted. But it would be a mistake for us to simply want to say all of them are useless, they're callous, and I think that would be a mistake on our behalf. I think there's a general misunderstanding of what commissions of inquiry seeks to do sometimes. Yeah. The idea is get the fact, establish the facts, provide the evidence, make recommendations that have been substantiated with facts and fact-finding missions. So the commissions in themselves are investigative, get to the bottom of the issue, find the facts, put the truth across and make recommendations. Sometimes what then becomes a problem is if we're not able to act on the recommendations that are made. Case in point, the high-level panel on state security agency, for example. There has been recommendations that were made by the panel, but we've not been able to implement that. So I think there's a checks and balance question that we need to ask ourselves. Yes, some have been whitewashed, like we've seen with the Seriti Commission, but other commissions, for example, what is transpiring out of the Zondo Commission is that there's a whole lot of information that has been put outside. Now, the question for us to ask is, when is the state going to act, right? And when does political interference stop at the level at which then people can then therefore be held accountable? Because some of these commissions of inquiries have actually been scathing with regards to what they've uncovered and actually put forth very useful recommendations. So on the one hand, we understand the weaknesses that we've seen with some commissions, but it would be a mistake to actually think we should completely wipe them off.
Yeah.
So we just need to orientate ourselves a bit more better with what the state of the commissions of inquiry can do for our own development as a society.
Terry, following the judgment last week, you sent out a statement, an 8-point statement on what you'd like to see going forward. Please just unpack that statement for us.
Thank you. Essentially, I said that there is enough evidence, but we don't need to have another commission inquiry. We need action. Obviously, the NPA is somewhat overloaded, but in terms of the financial implications of the arms deal, the Cabinet was warned in 1999 in a 57-page affordability study that the arms deal was a reckless proposition that would lead the government and the country into mounting economic and financial difficulties. Now, the documentation that was distilled into that 57-page report is held by the National Treasury. I estimate there are about 17,000 pages in that, in the International Offers Negotiating Team and Financial Working Group papers. In terms of the subpoena for me to testify before the Seriti Commission, I was entitled to documentation, and those were the documents I demanded. I was blocked from investigating those or seeing those documents, and eventually, when the Seriti Commission report came out, National Treasury had falsely claimed that those documents are privileged, and therefore I was not allowed to see them. Now, I think it's within the capacity of the President to demand from the National Treasury that we see what went into those documents and how they were distilled into the affordability study, because they cover the loan agreements negotiated with, for instance, Barclays Bank for the warplanes, Commerzbank with the warships. The Barclays Bank loan agreement is still current. We borrowed for 20 years. The default clauses in that agreement are, I would say, as a former international banker, a textbook example of third world debt entrapment by the British government and British banks. And former Minister Trevor Manuel's legal counsel admitted that they were potentially catastrophic for South Africa. That has to be examined. How did we get into this mess, and how do we get out of it? Because those agreements have been guaranteed by the European governments that put such massive pressure on our government to buy the warships and warplanes that we did not need and actually could not afford.
So this afternoon I spoke to Judge Seriti in an effort to come, to invite him to come and join this conversation, which he declined. Of course, he's not here tonight, but he was saying that he stands by his findings. What do you think of that?
I'm afraid Judge Seriti was trying to, well, it was revealed before the hearings even started that Judge Seriti had a second agenda to silence the Terry Crawford-Browns of this world, not just me, but also Andrew Feinstein and others. So we were blocked from referring to evidence such as the affordability study that has been in the public domain since 2001, but suddenly became reclassified. The Debevoise and Clinton report, which revealed a corruption around Ferrostal, which managed the submarine and warship contracts, he blocked that as well, even though they revealed that, in fact, the Germans had only met 2.4% of their offset obligations, and offsets were simply vehicles to pay bribes.
All right, Thami, I'd like your thoughts as well on the response by Judge Seriti in terms of standing by his findings. That's only after this break. You're watching Unfiltered. Stay with us. We'll be back after this.